This is an example of a council being stupid and stubborn with a penalty charge notice. I know it sounds rude and it's just my opinion, but I'm going to call it as I see it, because my viewer wrote to me saying that they challenged this penalty charge notice, and this was the response. I quote, "Your challenge against this PCN has been rejected because from the 8th of April 2024, the concession allowing electrical vehicles to park in the pay-to-park bays for the maximum stay of 10 minutes payment has been withdrawn. Electric vehicle drivers must now pay the full duration of their stay." In other words, previously the concession was that electric vehicle drivers could pay for just 10 minutes and stay for the maximum stay. But that concession had been withdrawn from the 8th of April. However, the sign still stands to read as follows. It says, electric and plug-in hybrid vehicles can park for the maximum stay during the chargeable hours upon purchase of a 10-minute parking period. Now, if that is what the sign says, and the person with an EV parks there to charge, pays for the 10 minutes and stays to charge for the maximum stay, which is indicated on another sign, then those are the terms they've agreed to. Whether this is a penalty charge notice or a private parking charge notice, you cannot be punished for doing something that wasn't made clear to you on the signs. Now, there are a number of different challenges you can make to penalty charge notices and parking charge notices, all of which are broadly the same. The main one is that the contravention did not occur, either because you didn't break the rules that they say you did, and that's quite clear, or the signs say one thing and you complied with the sign and they are saying, well, you did something else and therefore you are liable to this charge notice. But if you haven't gone outside of the terms of the sign, whether it's a penalty charge or a parking charge, no court or tribunal is going to uphold any breach of a term that wasn't made clear to you. This is basic common sense, and I would have hoped that a council would see the challenge to say, well, this is what the sign said at the time that I parked there. I parked within the terms, i.e. I paid for the 10 minutes with my electric vehicle and stayed for longer than 10 minutes or up to the maximum stay. So I shouldn't have to pay a penalty charge notice because that wasn't made clear to me. So if you're in this situation, it is open to you to appeal them. I suggest you do it quickly. I suggest that you put all of your evidence together. You take photographs of the sign. I always take photographs of the sign immediately when I park, just so that if this kind of thing happens, I have the evidence, the contemporaneous time-stamped evidence exactly from when I parked the vehicle. So if they come back later and give me a penalty or a parking charge notice, then I can go back and say, well, this is what the sign said, here's what I paid, I'm within the terms of that sign, so I'm going to challenge it. And so I would certainly hope that when this goes to a full tribunal, that this penalty is then cancelled. So if you end up in that situation, gather all the evidence, put your arguments together. I hope this video is some guidance to you because these are now getting quite ridiculous. So again, this is all just guidance. These are just my views, but hopefully that'll be useful to you. And so do take my warning. Take the photographs, keep the evidence, and make your representations. And with that, thank you for watching. I'll see you next time.